All right, here we go. Good evening, ladies and gentlemen. My name is John Moser, professor of history and chair of the Master of Arts in American History and Government program at Ashland University. Welcome to our third season of Documents in Detail, teachingamericanhistory.org's webinar series. In each episode, we'll do a deep dive into a single document, discussing the historical, literary, and rhetorical aspects of said document, while also analyzing its impact on American history, people, and thought. TeachingAmericanHistory.org is a project of the Ashbrook Center, a nonpartisan nonprofit organization based at Ashland University. We provide a variety of programs and resources for teachers of American history, government, and civics, all based on the use of primary documents. In the next week or so, you will receive an email with a link to request a certificate of participation, if you like, as well as a link to the archived video and audio from today's program. The topics of this year's webinars are drawn from speeches, letters, and writings from the Ashbrook Center's extensive document database available at tah.org. And you too can participate in the discussion by typing your questions into the chat window at the bottom of your screen at any time, and I will do my best to get to every question. The subject of today's program is the Bill of Rights, and to help discuss it are Dr. Jeff Sickinga. Well, we hope he will be here to discuss it soon. Dr. Sickinga is professor of political science and co-director of the Ashbrook Scholar Program at Ashland University, and the present Dr. Adam Seagrave, associate director and associate professor in the School of Civic and Economic Thought and Leadership at Arizona State University. Adam, it's great to have you with us tonight. Let's just start off with a basic question. It sounds a little bit silly in this instance, but I always start these by saying, why is this document important? So let's start with that.
Yeah, thanks, John. Yeah, it's really great to be here to talk about the Bill of Rights. So why is the Bill of Rights important? Many reasons, of course. I think in terms of our looking at the contemporary state of American politics, the Bill of Rights is important largely because of the body of constitutional law that it has given rise to through the Supreme Court's exercise of its power of judicial review, and particularly after the 14th Amendment and the incorporation of the Bill of Rights against the states, that it essentially has been transformed into a powerful weapon of the Supreme Court, right? To limit, to check the power of state and national legislatures, perhaps more so than it was initially envisioned to do. So it's important for that reason, for the developments in terms of balance between the branches of government and the separation of powers. Those sorts of things that have changed over time. It's definitely helped to affect that change. It's been important, I think, also for the reasons that Madison and others hoped it would be important, that it lays out certain maxims of free government that have made its way very much into the consciousnness of the American people, the American public. And so the Bill of Rights has been something that people hold on to as a statement of fundamental principles of free government. And so it's been important, I think, for that reason as well, and has achieved some of that effect. So those are a couple of ways in which I think the Bill of Rights has been important. I guess a mixture of positive and negative, perhaps.
Yeah. Okay. Jeff, I see that you've joined us now. I hope you can hear me.
I can, yes.
Excellent. The question that I asked was one that I admit seems a little silly in the context of what we're talking about, but I always begin these webinars by asking, why is this document so important?
Yeah.
Is there anything you would care to add to Adam's answer?
No, I think what Adam said is exactly right, and I would just let me magnify a little bit about the second point. Madison did hope, as he was saying, that the Bill of Rights in the end, he actually says in a letter to Thomas Jefferson, I've always been in favor of a Bill of Rights, contrary to what some people said about Madison, but I never thought it was essential, but it always could serve a couple of very important purposes. I think he says this in a letter in October of 1788. And one of the purposes he says is exactly as Adam was saying, it can educate the people and keep these rights in the public mind going forward. And actually, for two purposes. It's good to have the people educated so they can watch government and make sure government's not encroaching. But the other thing that he says, and it's pretty interesting in light of documents like Federalist number 10, where he says it can actually help educate the majority, not so that it understands the minority rights as well, so it won't act against those on its own or through government. So that unpopular minorities will be understood, for example, to have freedom of speech because it's in the First Amendment.
That's very interesting. But there's one point that you made, Adam, that you were talking about its impact on the Supreme Court. Is it an exaggeration or a major exaggeration to say that there's kind of a straight line that goes from the Bill of Rights to the concept of judicial review?
I guess I would say that not so much that the Bill of Rights led to judicial review so much as with judicial review in place, the Bill of Rights magnified the power that the Supreme Court would have. So yeah, I'm not sure how closely those two are connected in terms of causality, right? But the Supreme Court, I think acquires more power through judicial review with the addition of the Bill of Rights than it would have had without it.
Okay.
Yeah.
Jeff, any thoughts on this?
I think that's right. We see Supreme Court decisions early on, Marbury v. Madison being the most famous, that aren't actually about the Bill of Rights. And in fact, we get the Supreme Court in 1833 in Barron v. Baltimore saying the Bill of Rights only applies to Congress, and the actions Congress and the national government take, not the states. And it's really not until we get the incorporation of the Bill of Rights to the 14th Amendment that we really start to see the court using the Bill of Rights or deciding cases based on the Bill of Rights and expanding its power and its scope.
Good. Okay.
Yeah.
Let's talk a bit about the context for this. Why was the Bill of Rights only added in 1791, right? 4 years after the Constitutional Convention, 3 years after a sufficient number of states had ratified? Why 1791?
I'll speak to that. I mean, I think one thing that we overlook when we think back now about the Bill of Rights and consider the reasons for adopting it, we overlook the strength of the reasons against having a Bill of Rights that were voiced early on, and I think prevented its being included in the original document and explain why it wasn't in the original document. So, and I think the contrast that Hamilton mentions in Federalist 84, and that Madison mentions also, that James Wilson mentions, between the Constitution, the United States Constitution as it was conceived on the one hand, versus the British system of government as represented by the English Bill of Rights in 1689, the Petition of Rights, back to Magna Carta in the 13th century, that the English system required a Bill of Rights because it was conceived to be a different sort of government that wasn't built on the natural rights of the people. It was built on the prerogative of the king and the government, and so there needed to be these positive protections against the government. Whereas in the American form of government, it would be the opposite, that the government would come from the people, their natural rights would be assumed to exist, and that the government was only the agent of the people. So because of that kind of flip in the understanding of where sovereignty lay in the system, there were very strong reasons not to include a Bill of Rights, because it was conceived to be only appropriate to a system like the British system that was being rejected. So that was one reason why it came later, I think.
Okay, Jeff?
Yeah, I would echo that and say that that's the kind of theoretical reason, and then we do forget that argument. And it's funny because Hamilton actually in Federalist 84, as Adam was saying, actually is afraid that we will forget the argument, and in fact says not only is a Bill of Rights unnecessary, it also could be dangerous because people will begin to think the only rights you have are the ones specified in the text. And the Ninth Amendment tries in some way to kind of take care of that. But it's interesting if you ask students nowadays, including my college students, name me a part of the Constitution. The one text that, give me some text from the actual Constitution. They will give you something from the preamble or something from the Bill of Rights.
Yeah.
They will not actually mention anything of the Constitution itself, very rarely. So you might even say, to some extent, Hamilton's concerns have been kind of validated by the power of the Bill of Rights in the public mind. Also think at the time, people like Madison weren't so thrilled with the idea of a Bill of Rights because there was great fear that it would try and undo that adding a Bill of Rights would open up Pandora's box to all kinds of amendments to the Constitution, sort of undo the work of the original convention. And Madison was so concerned about that, as I think probably everybody knows, when he submitted this in the speech to Congress, when he submitted the Bill of Rights, he proposed that they not be in a separate place, but be integrated into the text of the Constitution itself. So as negatives, prohibitions on the power of the state or national legislatures, to, again, the idea of putting everything within the Constitution and preserving the text of the Constitution itself, and not adding something to it or breaking from it in any way.
That's very interesting. Now, Adam, you mentioned that the framers were not crazy about the idea of a Bill of Rights because they didn't see it as necessary as it was in the English Constitution, because the people are assumed to be sovereign. But given what Federalist 10, for instance, says about the possibility that a tyrannical majority could impose its will on a minority, wouldn't the Bill of Rights be regarded as a natural check against that?
Yeah. Yeah, I mean, I think, and that's that's the argument that I think Jefferson, for one, gives in a letter to Madison, and many of the Anti-Federalists, right? That, I mean, doesn't it just make perfect sense to do anything we can to check the potential power of a tyrannical majority in government? And so, I think that's ends up being a powerful argument, and ends up being the decisive one in terms of why we do adopt the Bill of Rights, because, well, doesn't it make sense to check tyrannical government in every single way possible that we can? So I think that's right. So although on the other side, though, the argument nevertheless is powerful that that Hamilton gives, that this will introduce a misconception of the source of our rights, right? That they're given by government, as Jeff mentioned, that they're not natural rights, and I think that's a real danger, and that when you hold on to the Bill of Rights as all you've got, rather than the theory of government that stands behind the Constitution, I think that's the danger that Madison and others feared, and as Jeff says, has largely, I think, come to pass. And so now we really do need the Bill of Rights, almost because of the negative effect that the Bill of Rights has had in helping us misunderstand where our rights come from.
Yeah. So in 1789, by 1789, Madison has clearly changed his mind on this, right? He's actually the one who brings it before or proposes a Bill of Rights to Congress, correct?
I won't allow that Hamiltonian slander.
Oh.
No, Madison himself does actually say, I've never been opposed to a Bill of Rights. So he wasn't enthusiastic about it for immediate political reasons, among others. I think his reasons were, again, ended up supporting it, were partly political. Obviously, political deals had to be made and promises were made to the Anti-Federalists, among others. I mean, the Anti-Federalists' concern were probably not Madison's concerns about the effect of a Bill of of Rights, Madison is worried, as he says in that letter to Jefferson, a Bill of Rights to prevent a tyrannical majority from acting against a minority. I think a lot of the Anti-Federalists are still thinking along the lines Adam was saying about the English government. The Anti-Federalists are worried. They want a Bill of Rights to prevent action against the majority by a tyrannical minority, an aristocratic clique, an oligarchic clique that would gain control of the national government and use it to suppress the people and their liberties. So that's the real, the animating concern of the Anti-Federalists was a kind of populist concern to preserve the liberties of the people.
And to pick up on the point Jeff mentions about Madison's consistency, so I agree with that. I think Madison is consistent both on this point and on many others that people think he's inconsistent on. But Madison, when he introduces the Bill of Rights in his speech in Congress, he says that he judges a Bill of Rights to be neither improper nor altogether useless. And so, he doesn't end up being a big proponent of the idea of a Bill of Rights, even when he introduces them and argues for them in Congress. As Jeff said, it's more of it's for political reasons, and moreover, he doesn't think it's as he says, it's not useless and it's not harmful or improper necessarily. So he'll go along with it.
To Jeff's point, Madison's June 8, 1789 speech. He says, I wish, among other reasons why something should be done, that those who have been friendly to the adoption of this Constitution may have the opportunity of proving to those who were opposed to it that they were as sincerely devoted to liberty and a republican government as those who charged them with wishing the adoption of this Constitution in order to lay the foundation of an aristocracy or despotism. So, some pretty clear political motive for getting this out there.
No question about it. Yeah.
Let's talk a little about the inspirations for the Bill of Rights. We've mentioned the English Bill of Rights, which may not have had much influence. The Virginia Declaration of Rights, maybe. Are there other documents or thinkers that would have inspired Madison and others in putting forward these particular rights?
Well, I mean, you mentioned a couple of them. Obviously, the English Bill of Rights is an important antecedent. I tend to think that not enough attention is given to the state constitutions of the Revolutionary era, and including the state bills of rights, among which is the Virginia Declaration of Rights. A lot of the rights that end up as amendments in the Bill of Rights come from places like Virginia, conventions in all the other states in which minorities or majorities of the delegates say we want these rights included, and they list those down. And Madison has a pretty comprehensive list of all of those, most prominent of which is from Virginia. And a lot of that language goes right back to language from those state bills of rights. One example, most obvious one, Madison himself contributed to the Virginia Declaration of Rights in section 16 talks about the free exercise of religion, which Madison in 1776 insisted be put in there in place of toleration, free exercise of religion. And he uses the same language, partly because it's his, but also because it's coming from his home state for the First Amendment.
Wow.
Yeah, no, I'd agree with that. As the state constitutions and bills of rights has important precedents. And maybe even a little bit before that, there are things you could point to in the Stamp Act debates, the petitions that the colonies sent to the House of Commons, House of Lords, and the King during the in protest of the Stamp Act. That you start to see some of the things that will later be echoed in the Bill of Rights. One issue that comes up then and later the next decade as well is trial by jury is a big one, with the British introducing the trial by courts of admiralty in violation of the Navigation Acts and the Townshend Acts. So trial by jury, that's a big one that's around even before that. But yeah, I do think that all of the colonial and then state level declarations of rights that are percolating throughout this the pre-revolutionary and revolutionary era they are all influenced as well by the tradition of British thinking about rights that's reflected in the English Bill of Rights, and also back to Magna Carta. There are particular provisions in Magna Carta that are reproduced almost exactly into the Bill of Rights. So that as well.
We've mentioned how the Bill of Rights was introduced in part to placate the Anti-Federalists. Shaylin has asked, to what extent were the Anti-Federalists satisfied by this?
I mean, I guess I would say I think they were at least placated by it. Perhaps not satisfied, and it might depend. There are differences too among particular Anti-Federalists. I don't think it ended opposition from some of the most ardent Anti-Federalists, but certainly, as Madison said, it was something that was necessary to blunt the harshest criticisms and opposition of Anti-Federalists, and I think it did that. I mean, at least it forestalled or prevented the calling of a new constitutional convention, or it blunted those most severe criticisms of the Anti-Federalists. So I think it was successful, clearly, in that regard.
Okay.
Yeah, I mean, there were certainly a couple of things, a couple of rights that or changes to the Constitution that the Anti-Federalists wanted. I think Adam's right. It really does depend on the person, right? Part of the problem with the Anti-Federalists is they know what they oppose, but they almost never agree on what they're in favor of. The Anti-Federalists were for things, as Herb Storing says in that book, but there's a lot of difference among the particulars in a way that was more common mind among many of the Federalists. But I think a couple of them were that they they didn't get in the original Bill of Rights, and remained sore spots for a lot of them. Size of legislative districts. They thought there were way too many people and not a constitutional limit on the size of legislative districts, which they thought would be a very bad thing. And I think also the lack of a prohibition of a standing army was a real problem for a lot of Anti-Federalists that did not get addressed. And you could say the Second Amendment attempts to address that sort of by making sure the federal government can't disarm the people from whom the militia is drawn, state militias are drawn, but that's an indirect prohibition. They would have much rather preferred, many of them, a prohibition on standing armies in times of peace, and they didn't get that.
Okay. At the time when Madison proposed the Bill of Rights, June 8, 1789, neither North Carolina nor Rhode Island at that point had yet ratified the Constitution. To what extent can it be said that the addition of the Bill of Rights, or the impending introduction of the Bill of Rights, made a difference in those cases? Do you have any idea?
It made a difference in North Carolina.
Okay.
I mean, the amazing thing about the American Constitution is we have so many good records from the states in ratification debates, and pamphlets and newspaper articles and publications and all those sorts of things. It made a difference in North Carolina. There was real concern there, and the tide was close. As we know, right, they were very reluctant to ratify the Constitution. And so the existence of a Bill of Rights, if not all the specific details of what would be in it, became fairly widely known in places there, and did turn the tide, at least turned enough delegates that North Carolina came out in favor.
Adam, anything to add to that?
Yeah, no, I think that's right. And yeah, in the case of Rhode Island, I'm not as sure about that. I mean, my sense is that with the rest of the states having ratified, that Rhode Island was going to ratify, but that sounds right to me.
Yeah, we know that Rhode Island was just always a problem.
Jeremy has asked a question sort of in line with this, along the lines of political compromises being made. I've heard that the Bill of Rights America ended up with contained more rights that Federalists were in favor of than ones that Anti-Federalists were in favor of. Is there any validity to that?
That's a
Well,
tough one. Yeah, go ahead.
yeah, that's a hard one because I do think, as I said before, there were some, if you want to call it a right, is it a right to say no standing armies in times of peace? The Anti-Federalists certainly thought it was extremely dangerous to the people's rights to have a standing army in times of peace. So I would say that was certainly true. But the list of rights that got adopted, it came out of the state conventions, including the minority conventions, the minority reports, for example, of Pennsylvania and the conventions. And a lot of those were actually incorporated in the language. At least Madison thought he was incorporating those things as he wrote the text of the language. So he would not have thought that he was deliberately omitting or trying to kind of, by careful writing, exclude some important rights that were widely demanded by the Anti-Federalists.
Okay.
Yeah, that sounds to me like at least like a largely unsubstantiated, conspiracy theory type thing. If that's, to say that it was, mostly things the Federalists wanted anyways, as opposed to things the Anti-Federalists wanted. I don't know. I definitely wouldn't. I don't see the basis for saying that. Although, as Jeff mentions, there were certainly a couple that the Anti-Federalists wanted,
The only other
that they
thing
didn't
that
get.
comes to my mind while we're thinking about this now is some Anti-Federalists wanted a limitation on the necessary and proper clause.
Uh-huh.
So they wanted it to go back to the sort of Articles of Confederation and make it clear, expressly enumerated. And so to deny the doctrine of implied powers or make it very narrow. And that was not accepted, obviously.
Hmm.
So is that a right? It's not exactly a right, but it is a limitation on the power of the central government. And they didn't get
Well,
that. And then the Federalists would not have supported that. And they would have opposed any kind of restriction on that.
yeah. Although you could say that the Ninth and Tenth Amendments, add up to that, at least on one interpretation of it. But you're right; it's not tantamount to an explicit uh, limitation of the necessary and proper clause that Anti-Federalists would have wanted, right? But
Right.
right, but I don't know. The Tenth Amendment does end up being a powerful tool along those lines later. Although,
Yeah. And in
yeah,
fact, I think, and that's a good example probably of the politics takes that over, right? And that concern for the preservation of state authority becomes a key part of the Democratic Republicans and Jefferson's party. So that stream of anti-federalism definitely continues politically all the way through, well into the Civil War.
yeah.
Nicole Spencer asks, well, you mentioned that Madison feared opening Pandora's box for changing the form and structure of the government in creating amendments from the beginning. Were there any movements, especially by anti-federalists, to try to change any of that as they were discussing what became the Bill of Rights?
Oh yeah, definitely. There, in the ratification conventions, when you read them, in several of the states, people say, why are we debating ratifying this? Why don't we right now propose changing things? So a most obvious example was in the constitutional conventions and the ratification conventions. A lot of, especially Anti-Federalists, did not like a unitary executive. So they said, oh, the states right now have governors. The states have governors with executive councils, or they have a council of state that functions as the executive. We ought to change the Constitution and demand the change and go back to that form of executive. And so you had proposals to actually modify Article 2.
But what about after ratification? But Madison was concerned that this was going to open the door to bigger discussions. Did this sort of thing start to come up in 1789 and 90? Was there a free for all? Did those anti-federalists that happened to make it into the first Congress see this as blood in the water?
Oh, I see what you're saying. Yeah, no. Partly, for example, on the executive, when the debate came forward about accepting the new amendments, nobody that I know of said, so now we need to go back and change Article 2 now. In part because, of course, George Washington is president, and a lot of the Anti-Federalists are happy with George Washington, or at least think he can be trusted. So, no, they didn't open Pandora's box in that way.
Okay. Adam, anything to add on that?
Yeah, no, that sounds right to me. Yeah, I know. Well, that just brings just another instance of George Washington's presence being so important. I think that's noteworthy. I mean, at the convention, and then again later as president, obviously, that George Washington just being there was key.
Okay.
It is a remarkable thing. John, it's just worth noting. It is a remarkable fact that you had such powerful resistance to the adoption of the Constitution. And many states are, as we all know, right, just ratify the Constitution by a whisker in their conventions, in their state conventions, just barely. And yet, once the new Constitution is adopted and the new Bill of Rights is added, or even during the debate over the new Bill of Rights, the acceptance of the basic constitutional structure and form, it's remarkably, it's embraced and it coalesces. And people who are anti-federalists begin to say, we need to preserve this Constitution. So an obvious example, most famous example of that is Patrick Henry, who's an anti-federalist and comes out in 1799 as a Federalist. It's really remarkable how patriotic sentiment coalesced around the Constitution very early on.
Did Madison and the other founders ever suggest that they regarded some of the articles that made it into the Bill of Rights as more important than others?
Well, I think for Madison, I would say certainly the religious freedom part of the First Amendment, he always regarded that obviously as very, very important. I don't know, definitely more important than some others, for sure, in Madison's case. I mean, he authors the Memorial and Remonstrance against religious assessments in Virginia, and he mentions freedom of religion in particular when he's writing. I think it's to Jefferson about the Bill of Rights, and saying that essentially it could be dangerous to write down and put in a Bill of Rights the freedom of religion because you couldn't define it broadly enough, right? That it would be understood too narrowly if it were written down. So I think Madison in particular repeatedly shows concern over the freedom of religion in various forms as being of really central importance. So that's one thing that immediately comes to mind in terms of an order of priority.
Okay.
Yeah, and Madison, just to go off of what Adam said, Madison, when he proposed the Bill of Rights in that speech to Congress, he proposed adding some things to Article 1, Section 10, which is powers that are taken away from the states. And the three things that he proposed were rights of conscience, that states can infringe rights of conscience, right to trial by jury, and the free press. So he clearly regarded those three things as important enough that even states should be prohibited from infringing on them.
Gotcha. Well, let's talk a little bit about how the Bill of Rights was received. We've already mentioned the extent to which it satisfied or failed to satisfy anti-federalists. But was there, based on the popular press at the time, was there excitement about these 10 amendments to the Constitution?
Yeah, I mean, it was kind of I think of it sometimes as the original era of good feelings. It seemed like, yeah, they did what they said they were going to do. They made these promises to us, and as Madison suggests in the part of the speech that you read, John, yeah, you see, we want to prove to people that we're friends of liberty and Republican government, and they were widely received by people as, in fact, yes, these are things that show that the Federalists were operating in good faith, despite our original concerns. And you had people, like George Washington, among others, widely respected people who were supporting these things. And you really didn't you had someone like Hamilton, who writes the Federalist number 84 against a Bill of Rights, not coming out in public against it. So it was one of these sort of universally, unanimously embraced and adopted, and everybody said, you see, we promised it, and the other folks said, you did, you're right, and you actually did it, thank you. And so there was this moment of really national, it's probably been some of the least contentious amendments ever proposed.
Wow.
Yeah. Yeah, not to. I agree with all of that, and not to bring it too much into the contemporary context, but I do think it's a really instructive contrast with a lot of what we see in recent American politics, because you had a clear instance where there was contention and disagreement, obviously, over it. You had an opportunity for really heated controversy between the Anti-Federalists and the Federalists right at the beginning, when the Constitution was so precarious. But yet, instead of that materializing, what you had, as Jeff says, was an emerging consensus, essentially, and a show of good faith from both sides on the basis of common understandings, more fundamental common principles. Going back to what Lincoln says, about 1776 being the origin of the American Union, you see some of that coming, sort of showing itself in the early years of the Constitution and with the adoption of the Bill of Rights, because you see the fact that there was an underlying consensus or an American mind about principles of government that allowed for these kinds of debates to be had and for these changes to be made. 10 amendments all at once to the Constitution, without giving rise to turmoil and sort of rifts that couldn't be healed. So I think that it was a really good example of that fact of kind of the underlying agreement on principle that allowed for the resolution of subsequent disagreements about things like whether we should write down the Bill of Rights.
Very good. Nicole Spencer asks, can you expound on what exactly rights of conscience entail, and how might these rights have been infringed on by Supreme Court rulings?
Well, it's a big one. But let me say, I will say, my own opinion is, as Adam was saying, Madison was actually worried about writing down and specifying and enumerating religious freedom or rights of conscience, not because he thought they would be taken too broadly, as sometimes people are worried about now when you write down rights and people expand them too far. He thought they would be interpreted too narrowly, as Adam said. But I think, to my mind, that shows you that Madison's views on religious freedom, I think they're really important and deserving of deep study and understanding. But even Madison himself may have understood that where his mind on that issue was not exactly where everybody else's mind was. And that he had a broader understanding, for example, of religious freedom, and he and probably Jefferson did, than others of the time. And so you get their bill for establishing religious freedom in 1786 in Virginia, and that's what Madison believed was, in fact, what the law and public policy should look like if it embraced religious freedom. And that went much farther than a lot of states at the time in separating church and state, for example. So I think Madison's understanding of religious freedom was very broad, and it meant things like government had no power over the conscience of the individual. It stayed with the individual. So Madison, as president, said, I don't even feel like I have the authority to issue Thanksgiving proclamations, because I don't think government should be telling people or even advising people what they should do about their religious exercise. But obviously that wasn't a sentiment shared by people like Washington.
Okay.
I agree with all of that. Right, that Madison does have this broader understanding of freedom of rights of conscience as something broader than freedom of religion, even. Madison's understanding of religious freedom or the rights of conscience too is somewhat different from the way the Supreme Court has the way the constitutional law has developed, I think, on the issue, because I think some have argued, and I think is right, he would say essentially that legislation should never should never take any cognizance of religion or conscience whatsoever, because that's not its realm. In other words, that when the social contract was made, that people's conscience, their religious beliefs or non-beliefs, that's a decision that is sort of prior to the entire social contract and off the table from the beginning, so that the government can't legislate in any way whatsoever respecting religion. So even things like accommodations, the accommodationist position Madison, I think, would be opposed to. And that so his broader understanding of what freedom of conscience entails would also in some ways actually limit religious liberty in the sense we understand it sometimes today in terms of accommodating religious belief in legislation, because Madison would just say, just complete hands off, right? Yeah, nothing at all to do with religion positively or negatively.
Yeah, I've heard it said that Madison would have certainly objected to tax exemption for churches. Andrew asks, is there anything to be read into the Virginia Declaration of Rights at the reference to the word Christian in Part 16? As I dig through to find mine. Yeah, this is the final part.
Charity and forbearance, right?
Mm-hmm.
That's right. According to dictates of that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other.
Yeah, that's right. And in fact, Patrick Henry made a lot of that.
Mhm.
So in 1784-85, he introduces a bill which occasioned Madison's memorial and remonstrance in attacking it, a bill for establishing a provision for teachers of the Christian religion. And Henry argued it was a bill to impose a tax on everybody in Virginia, and it was a tax that the state government imposed on you. The county sheriffs collected it, but it went toward your own religious denomination. So they taxed you and sent your money to your church, essentially. And Patrick Henry said, that's not a violation of the rights of conscience, because we're not forcing you to give to a church that you don't believe in. We're just saying that you should give to the church that you support. And he claimed that it would be for the Christian religion, which he said, and that's not contrary to our Declaration of Rights either, which talks about Christianity there in section 16. So he thought it was utterly consistent with the rights of conscience and the mention of Christianity there.
Yeah, and that's that kind of picks up on the common understanding of toleration and freedom of religion at the time, going back to Locke, I guess, and before that, that the idea that religious toleration was within sects of Christianity, right, rather than beyond Christian sects. And so I think that, right, that understanding is evident there to some extent, that freedom of religion means freedom to profess various versions of the Christian religion. But again, people like Madison and certainly Jefferson had broader ideas about religious freedom than that, and Washington as well. So many leading founders had broader ideas. But yeah, it is interesting that in that very point, affirming religious freedom, that Christian, explicitly Christian principles are mentioned. And I think it does, though, also single out, a way in which the Christian religion is, of course, particularly open to the idea of religious freedom, I think. I mean, Protestant Christianity maybe in particular, but that it's easy to include within Christian principles the idea of toleration of people of other beliefs, because of this principle of charity. You think too about Lincoln's second inaugural, closing with, malice toward none and charity toward all. I mean, that's that's in a sense, he doesn't mention Christianity there, but it's certainly a principle that is associated with Christianity. So there is kind of a natural harmony there, but also I think it is reflective of the narrower understanding of religious freedom most at the time than we have today, probably.
Yeah, I'd say that's right. And there is even a notes by Jefferson where he brings up this issue of in the convention. No, Madison, I'm sorry, brings it up and says in 1786, when they're trying to get Jefferson's bill passed in the legislature, and somebody wanted to put it that it's against the holy author of our religion, Jesus Christ. And Madison says, and that was stricken out. That amendment was voted down. So, because it was thought to give handle to the idea that religious freedom was only meant for Christians, and he says was not the understanding of people there. Now, it might have been, but it was certainly not his understanding, and it's not the understanding that he wanted to promote. That religious freedom meant religious freedom to practice your religion, whatever your religion was, Christian or not. But he pointed to that moment as saying, so it wasn't for to be limited to Christians. And that famous letter from George Washington, the Hebrew congregation at Newport, right, where he says it's no longer thought of as toleration, but as a natural right of all.
Okay. Ellie Koss asks, it seems to me that so many of the rights in the Bill of Rights seem cornerstones of American ideals and have become more important over time. Then there's the Seventh Amendment. Was that a more significant amendment in its time that simply lost its potency? My students always get a kick out of the $20 portion. I would also add, one could say the same about the Fourth Amendment, which doesn't seem to have a whole lot of
I think you mean the third.
Oh, sorry. The Third Amendment. Right. Oh, definitely. Yeah, definitely the third, not the fourth.
I teach a whole class for our master's program on the Fourth Amendment, so
yes,
that's relevant.
Yeah. No one's teaching any courses on the Third or the Seventh Amendments, though, right?
That's right. Yeah, I mean, it's so interesting, and I think those two are until 2008. Well, 2010, I guess, 2008, 2010, when the Second Amendment became acted on by the Supreme Court. Those are two rights that have not been, for example, they haven't been incorporated against the states. Mm-hmm. And there are other particular parts of the Bills of Rights that have been rejected by the Supreme Court as applying also against the states, in addition to the federal government. So, but the Seventh Amendment and Third Amendment, I think it's partly the Seventh Amendment. Of course, it's a really important amendment, jury trials, but it's because of the monetary minimum that's so easily surpassed that it became irrelevant very quickly.
Yeah. Adam?
Yeah. So, I mean, the Seventh Amendment, it's almost as just an extension, right, of the Sixth Amendment. I mean, it could have been just sort of added, it's continuation, right? At least now, in our time, it can be viewed that way, I think, right? Just elaborating on the importance of trial by jury.
But I do think it goes to a point that Adam raised earlier, which is very interesting, which is when the Supreme Court has looked at the Bill of Rights, depending on the justice, but I think it's fair to say probably the general view of the Supreme Court over time has been some rights in the Bill of Rights are really more important than others. So freedom of speech, they said, the Supreme Court justices have said it's in the preferred position. Of all the rights that that the Supreme Court's going to be really vigilant about, we're going to be vigilant about these specific ones, one of which is freedom of speech. And some of them are much less vigilant about and much less concerned to put narrow restrictions on government. I think of one case, Kelo versus New London in 2005. It's a takings case of private property. And there the court 5-4 majority seemed pretty open to government being able to take people's private property and hand it over, in that case, to Pfizer Corporation for economic development. They didn't seem to show, the Supreme Court didn't seem to show great vigilance in protecting property rights as they have, for example, with freedom of speech.
Yeah, I would say that's right. It does seem like going back to the issue of priority and relative importance. I mean, there definitely is, picking out the Third and Seventh does kind of lay stress on that fact. There is a difference in importance among the amendments for sure. And it does seem that the first is in many ways the most important, maybe at least for practical purposes, because the Ninth and 10th, which are also very important, are not as easily enforced in courts. But yeah, so I think the first we can say is the most important. But then after that, there isn't necessarily an order of importance that follows the order of the amendments as they're listed.
Yeah, I mean, why is the third ranked so highly? Was the quartering of troops such a fresh memory in the minds of the framers that they decided it
Gordon Lloyd, who teaches for us in the master's program and who's taught a lot of the seminars, has a great website on the Bill of Rights, which I recommend to everybody, which you can get at through teachingamerica.org. But what he notes there is the order of the Bill of Rights, right? First of all, it was 12 and not 10. So they were the first two. So the First Amendment was actually the Third Amendment when it went out to be ratified. And then why was it in that order? And it's because a clerk, these were proposed by Madison to be inserted in the text of the Constitution. And the clerk just took them out when they decided we're not going to do it that way. We're going to have them voted on separately as a separate part attached to the Constitution.
Gotcha.
A clerk just put them out and wrote them down in order as they had been put out by Madison according to the structure of the Constitution itself. So there's actually no logical, the First Amendment isn't first because it's most important. It was third, and it was only third because of the order that some clerk wrote it down in.
Yeah, that's interesting because if you look at Madison's June 8, 1789 speech, he lists amendments, and then he says that this particular amendment is the Bill of Rights because it includes all these things, a number of things that got broken out into separate amendments. That makes a lot more sense now. Thank you.
Mm-hmm.
Well, we're getting near the end of our time. Sort of by way of wrapping up, it occurs to me that there are really no other amendments that do quite what these 10 do, in the sense that subsequent amendments don't really add rights. Now, they may extend these rights to other classes of people, or certainly the Supreme Court has identified other rights as penumbras and emanations of things that have been stated. But am I right in saying that there's really nothing else, no other amendments that have sought to add more rights to what the first 10 recognized?
Yeah, I mean, I think that's right. That and what we've seen actually, and if you look at the amendments ever since then, so the last say 17 or so, what you get is those rights are really, in my opinion, I mean, some of them are, prohibition and social policy, and some of them are some structural changes about, president for 2 terms and who takes over the president and things like that. But beyond those, essentially these amendments are about the democratization of civil rights and the extension of civil rights to various groups and classes of people throughout, and a kind of increasing democratization of the political process that gets constitutionalized in these ways, 18-year-old vote, et cetera, et cetera. So I think, yeah, that these are, because as Adam says, the original Bill of Rights was understood to be a kind of extension of pre-existing rights, whether they were English in origin, like trial by jury, or whether they were natural rights, like freedom of speech or religion. They were understood to be the codification of pre-existent rights, not natural or English rights, not the extension of civil rights. And that's sometimes a confusion when we look at the right to vote. Is it a natural right? Is it a right? It's a civil right that people hold as citizens, not a natural right that they hold as human beings.
Gotcha.
Yeah. Yeah, I think that's right. I would agree with that. And similarly, a right like I was thinking the rights of equal protection of the laws that we get in the 14th Amendment, along with the echoing of the 5th Amendment's due process clause. But the right to equal protection of the law, similarly, I mean, that's an important, a very fundamental civil right that we get later, right, in the 14th Amendment that's not there in the Bill of Rights. But again, that's something that can be viewed too as an extension of a civil right that was of course assumed to be enjoyed prior to that by citizens. So we do get important statements of civil rights in later amendments, like the right to vote or equal protection of the laws. But yeah, not the enumeration of new fundamental rights that weren't understood to be there before, at least.
Mm-hmm. Well,
in fact, John, I would just add to that, it's one of those interesting things, like in the companion case to Brown v. Board of Education, the Supreme Court actually uses the 14th Amendment Equal Protection Clause and reads that back into the text of the 5th Amendment and says, well, there's no equal protection clause. There's no requirement in the Bill of Rights that the federal government has to treat each citizen equally. No, there's no explicit requirement of that. So, for example, could the Supreme Court say racial segregation is unconstitutional in schools in the states, but it's okay in the District of Columbia because nothing prohibits in the federal Constitution? In the case of Bowling v. Sharp, the court says, well, it just must be in the 5th Amendment. It's interesting that the Bill of Rights itself gets kind of explicitly updated by the court looking backwards through the 14th Amendment.
Huh. Well, we have just a few minutes left. Are there any final thoughts by either of you? What would you like to say to about 40 teachers about how they could introduce this subject to their students?
Jeff, you can go first.
Sure. Yeah, I think the Bill of Rights is always a great way to start talking about the Constitution. But I always the old founders' phrase, "The Constitution is a Bill of Rights," really can't be forgotten. The political thought underlying the Constitution and the Bill of Rights, the Constitution and the Bill of Rights itself points us back toward those things, and it's just impossible to understand the Bill of Rights or the Constitution without understanding the political principles and political theory that's underneath it. And I think sometimes we focus so much on the text and the particular text, say, of freedom of speech or something, that we don't think about the animating principles of, well, what is freedom of speech? Why do we have it? What's its purpose? And those are principles that the text of the Bill of Rights itself, those questions can't be answered by the text. You have to seek the answers outside of it. And the interesting thing is, I think that's exactly what the founders thought. If we lost the American mind in its understanding of the principles animating the text of the Bill of Rights, we would not understand the Bill of Rights. So it always asks us and pushes us to go back deeper and deeper into these principles and into the historical arguments and controversies surrounding them. Sure. Like the Alien and Sedition Acts, talking about freedom of speech and freedom of the press. You've got to push yourself back into those deeper political principles and historical controversies.
Yeah. No, I think that's really well said. I mean, I have not much to add to that, but yeah, what I might say, sort of as a version of what Jeff said, is that that understanding the original arguments that the founders gave against the Bill of Rights is maybe one of the best ways to understand the importance of and the meaning of the Bill of Rights itself.
Mm-hmm. Wow. Well, I want to thank both Adam and Jeff for their contributions. I also want to thank our participants for the really excellent questions. Just a reminder, you will be receiving in the next week or so an email with a link for a certificate of participation if you wish one. If you've enjoyed today's webinar, please consider taking an online graduate course through Ashland University and the Ashbrook Center. These are offered as part of our Master of Arts in American History and Government program. Both Jeff and Adam teach in that program. You can find more information about our online course offerings at teachingamericanhistory.org. And you can help us spread the word about these programs by sharing the archive link, which you'll be receiving by email. Please share that with your colleagues as well as on social media. Our next Documents in Detail webinar will be Wednesday, December 19th, just before Christmas, when our subject will be Thomas Jefferson's 1826 letter to Roger Waitman. At that time, I'll be joined by Dr. Todd Estes of Oakland University and Dr. Robert McDonald of the United States Military Academy at West Point. The recommended readings for that webinar have already been posted. We hope to see you back here on December 19th. Thanks again for joining us, and have a great evening.